Hello and greetings, everyone. We are Group 2 from Business Law Set 6 EPPA 2823, and this is our reflection video on the topic of unfair dismissal of employees. Our Group 2 members are Lizzie Hao, Yujia Chen, and Khadija Anisa. So in this video, we will be talking about the introduction, the legal background, the types and examples of unfair dismissal, the legal remedies and employee recourse, employees' perspective and responsibilities, as well as the conclusion. So what is unfair dismissal? The term unfair dismissal signifies when an employer ends an employee's employment without providing sufficient justification or adhering to the required legal procedures. Fundamentally, it happens when a worker is fired in a way that contravenes employment regulations or contractual duties, typically without reason or the worker's right to counsel. So why is this unfair dismissal relevant and still a current legal issue? Given how the work environment is changing today, this topic is still very relevant and becoming more and more important. Unfair dismissal is still a major legal concern due to changes in workforce dynamics, including remote work, short-term contracts, and economic pressures, as well as growing awareness of employee rights. For instance, the COVID-19 outbreak led to a wave of layoffs and cutbacks, which were challenged as being unfair either substantively or procedurally. In Malaysia, employment law places a high priority on unjust dismissal, and the Industrial Relations Act 1967 is what shields workers from wrongful terminations, and it's the main law governing it. Malaysia's legal system places a high priority on the employer's duty to provide just cause and excuse for any dismissal than other jurisdictions such as the UK or Australia. A larger dedication to ethical labor practices and industrial harmony is reflected in this legislative protection. The Employment Act 1955 and the Industrial Relations Act 1967 are the two main pieces of legislation that govern unfair dismissal in Malaysia. They are supported by case law and are well-established common law concepts. In the Employment Act 1955 includes basic terms of employment for employees making less than a specific wage, and it offers fundamental rights including notice periods, termination procedures, and severance payments. Um, the next one is Industrial Relations Act 1967, and in this act, an employee may file a complaint with the Director General of Industrial Relations under Section 20 of the Act if they believe that they were fired without an explanation. The industrial court has the authority to decide and grant reinstatement or compensation if the issue cannot be settled through conciliation. The case Gun Kui Poi versus JMP Coat Malaysia Berhad is an important case established that the employer has the responsibility of justifying that the dismissal was made with a valid reason or justification after it's contested. If this isn't done, the dismissal is unfair and the worker has the right to compensation. The case demonstrated how important court supervision is in shielding workers from unfair dismissal. Now, there are three key legal concepts, and the first one is just cause and excuse. Employees are required to give proper legal and supported explanations for termination, such as poor performance, misconduct, or redundancy. The second one is natural justice. And so before being fired, the employee must be given a fair hearing according to the principle. And this involves their right to know their allegations about them and their right to reply. The last one is due process. Before firing an employee, employers must follow a fair and transparent process. This entails carrying out appropriate inquiries, issuing cautions, and following disciplinary procedures. So together, these legal instruments and principles form the backbone of employee protection against unfair dismissal in Malaysia, ensuring that the employment termination is justified and carried out with procedural fairness.
Okay, types and examples of unfair dismissal. Dismissal without valid reason includes termination based on discrimination, for example, race, gender, and religion, and retaliation or bias, violates the principle of just case and executes under Industrial Relations Act 1967. Dismissal without proper procedure occurs when there's no domestic inquiry, no warning, and no fair hearing, and failures to comply with procedural fairness under natural justice. Next one is constructive dismissal, when an employee is forced to resign due to hostile work condition. Examples include Employer significantly reduces salary without reason, stress, harassment, or sudden demotion. This one is real-life cases, Malaysia and international. Gong Kongfeng versus GNP Code, Malaysia, BHD. Failure to show just case demand unfair. Next one is Western activating versus Sharp, UK. Example of constructive dismissal. Okay, next one. Legal remedies and employee resources. Filing a complaint. Employees may lodge complaints under Section 21 of the Industrial Relations Act 1967, timeframe within 16 days from the date of dismissal. Complaints submitted to Industrial Relations Department, GTKSM, and this one is Industrial Code of Malaysia. Possible remedies, right statement, employee return to former job if appropriate, compensation if right statement is not suitable. Court may award monetary remedy, usually capped at 24 months of back wages. Next one is mutual settlement, may be reached during consultation phase. Next one is legal process overview. One, complaint failed to GTKSM. Next one is consultation meeting held. Next one is if unsolved, refer to industrial court. And the final one is court decides on right statement or compensation. For the example and outcome in Gongkongfeng, failure to prove just case lead to compensation for their worker. And this one is core stress both substantive and procedural fitness. Okay.
Okay, good afternoon, everyone. I'm Li Zhihao, the leader of Group 2. Now, let's look at this topic from a different angle, the employer's perspective. We always hear about employee rights, but what about the employers? Can they just fire someone anytime they feel like it? The answer is no. Even in Malaysia, where employment is partly based on contract, the law is very clear. Employers can only dismiss an employee if they have a just cause and excuse. So, what does that mean? It means there must be a valid reason, like serious misconduct, poor work performance, or maybe the company is downsizing. For example, if a worker keeps being late or refuses to follow instructions, the employer might have a reason to act. But here comes the important question. Is having a reason enough? Can they just say you are fired, like in the movies? Not really. In Malaysia, employers must also follow the correct legal process. So, what should responsible employers in Malaysia do before they dismiss someone? First, they need to keep written records. That means things like warning letters or performance reviews. If there's no record, how can they prove anything later? Second, they must carry out something called a domestic inquiry. What's that? It's like an internal investigation. The employee is given a chance to explain or defend themselves. Third, the employer must follow the rules set by the law and company policy. It's not just about being right, it's about being fair. Sounds reasonable, right? Because if they skip all this, the employee might claim it was unfair dismissal and take the case to the court. So, what are the common mistakes that Malaysian employers make? Some don't even give a warning, they just dismiss someone on the spot. Others don't conduct a domestic inquiry, they go straight to termination. And in some cases, the dismissal is based on discrimination. For example, firing someone because she's pregnant or because of religion. That's clearly against the law. One more common issue is something called constructive dismissal. Have you heard of that? It's when the employer makes the right working conditions so bad, so toxic, that the employee feels forced to resign. Legally, that's still a form of unfair dismissal in Malaysia. So again, employers must be careful, not only to protect the workers, but also to protect themselves from legal consequences. So, what have we learned? In Malaysia, unfair dismissal means either there's no valid reason or the process wasn't done properly. And if that happens, the employee has the right to file a complaint, usually with the Industrial Relations Department. And sometimes they win compensation or even reinstatement. Now let me ask you, why does all this matter? It matters because fair practices help both sides. When employers follow the law, they create a positive and trusting workplace. They avoid lawsuits, and they also build a good company reputation. And what about employees? They also need to understand their legal rights, but also their duties. Respect and communication go both ways. So in the end, what protects everyone? Is it just the law? Yes, but not only the law. It's also about communication, fair process, and mutual respect. If both sides understand and follow their responsibilities, we'll have a better, more balanced working environment for employers and employees alike. Okay, that is the reflection video from our group. Thank you. If you have any questions, feel free to ask us.